Good morning. So let's go ahead and get started. Thank you very much for being here today. My name is Jim Marcus, and I'm one of the clinical faculty here. I teach in the death penalty clinic, capital punishment clinic. And this morning, we're going to talk about appellate and post-conviction review in the post-Gregg era. And we're very fortunate to have an incredibly distinguished panel today. So, and their full bios, of course, are in the program, so you can read those. But I just wanted to mention a couple of things. I'll start at the far end is United States Court of Appeals Judge Patrick Higginbotham. We were talking this morning. His career as a federal judge started in 1975, so perfectly spanning the post-Gregg era. Judge Higginbotham, in addition to being a very distinguished judge, is a friend to this law school, and he's also been an advocate for quality representation in capital cases, and has been involved in trainings up at the Center for American and International Law up in the Dallas area. So we're very fortunate to have him here. Seated next to Judge Higginbotham is Judge Keith Ellison from the United States District Court in the Southern District of Texas, which also happens to be a very active death penalty jurisdiction, so one in which Judge Ellison has had the opportunity to see many cases. Judge Ellison also has a very distinguished career and, among other things, has been involved in some public interest initiatives prior to becoming a judge, and has been a very thoughtful judge. One thing I wanted to mention, well, I'll get to that in a second, I'm sorry. And then we have two very distinguished advocates here. John Nyman, prior to being in private practice now, was the Solicitor General for the state of Alabama, and in that capacity argued several cases in front of the United States Supreme Court, including Maples versus Thomas, as relevant to our discussion today. And my former colleague, Rob Owen, now at Northwestern Law School, who is also a very distinguished oral advocate and has argued death penalty cases at all levels. I've seen Rob in action at the Court of Criminal Appeals, the Fifth Circuit, and also the United States Supreme Court, and he is also a good friend to us. So I have asked each of the panelists today to start by talking really about their first encounter with capital or post-conviction appellate litigation. So I will start, I think, down at the end with Judge Higginbotham, if that's okay.
Thank you very much. Let me first take a moment to give a shout out to the leadership that has brought you here today. These types of conferences are most important. The work that these people are doing is enormously important. We see that every day in the courts. Without the active engagement, the intellectual engagement of these issues, we would be far worse off condition than we are. So I do appreciate the opportunity to be here with you. I have great respect for the people who are engaged in this effort. Let me share briefly what my perspective is. You see where I'm coming from. I've been in one courtroom or another since I was 22 years old. So that's my 41st year on the federal bench, and I personally have tried hundreds of cases. I come from a viewpoint that trials work if you have them. My sharpest criticism of where we are today, and I want to give you that, and I want to back up and give you a little perspective about, I think, what the big picture is. My sharpest criticism is that we have moved away from basics. That is, the basic notion that a hearing is something other than an exchange of paper. That a hearing brings people into the courtroom. That it is a people's court. These cases cannot be properly decided without the context of an adversarial hearing, and I maintain that you can't do that as a paper matter. We see that infection in the federal and state courts of on the civil side of the docket, increased delegation to magistrates, secondary examination. By that I mean that the person who is the decider is depending upon somebody else's interpretation of facts which came to them in paper. So you're about 3 or 4 steps removed from the actual witnesses themselves. Trials work. The most powerful words in a civil docket that a trial judge can say to the litigants to move the case along is, counsel, call your first witness. It sorts things out quickly. Now, I say that it's very simple, but we have moved away from that. It's very difficult in this entire process, where, of all things, death is at issue, to engage and to require people to take the time and to do what they're supposed to do, which is to actually hear cases and not to decide them on paper. You say, well, the facts are all there. I can read them and I see there's nothing here to hear. Well, the facts aren't all there. We communicate in more powerful ways than simply by the written word. The witness is there, communicates by voice inflection, in all the ways that we communicate with each other. But those hearings have both intrinsic and instrumental values. The intrinsic value is that it provides a demonstration of engagement by the government and the judges with regard to this issue, because it's a public demonstration of that. It gives the satisfaction of being heard and not receiving your verdict by mail. Instrumentally, it serves to provide a more accurate means of getting at the reality of what has transpired. With that general observation, I want to back up for a moment and talk with you briefly about the whole habeas apparatus, and to remind you that this relationship between state and federal courts that is overlaid by the habeas system today is an enormously dynamic, moving, malleable structure. It is not a fixed matter. While we have the AEDPA there, it's essentially a stick on a pond. It is a fluid relationship. This dynamic is controlled by the Supreme Court, and it has controlled that in ways to solve problems. I don't mean that in a pejorative way. It's a reality of the way the system works. I remind you that and to give you the classic example of that, is that during the Warren era, the court made a number of decisions which created federal questions by the thousands in every criminal case around the country as they constitutionalized criminal procedures. That created an enormous number of cases out there, because now you had federal question jurisdiction in all these routine trials, and habeas petitions and direct appeal issues were there. The problem the court faced with this large number of cases was a reality. The court responded to that by the simple technique. It declined to take certiorari on direct appeal. So when it did that, the numbers of grants dropped to something around 2%. So you're not going to get heard by the Supreme Court first time around. Rather, it routed you through collateral proceedings, which, quote, vindicated federalism concerns, the state being a primary decider. But more functionally, what it did is to enlist the lower federal courts, the district courts and the courts of appeals, in the enterprise of discharging this huge influx of cases that they were facing, and enable them to exercise the powers of governance, which the court had taken to itself as early by the Judges Act in 1925, when ultimately it succeeded in gaining the power to decide what to decide. That, to me, is one of the cardinal sources of the Supreme Court's power and authority. It also changes it from a court of correction to a court of policy and governance within the framework of Article 3, albeit. But nonetheless, the court decisions rerouted that whole system. The court then also faced the reality that the Warren Court did at a fierce backlash. And the court reacts to, they would more than read the papers, they were sensitive to this. The impeach Earl Warren signs were around the country, and they were largely aimed at the fact that those decisions through the use of habeas were putting people on the street that have already been tried, convicted, et cetera. The court's response to that was to engage in an effort to make their decisions prospective only. Our good Texan Justice Clark authored the opinion for the court, which started down that path. A distinguished law professor in the foreword of the Harvard Law Review took on the court for that decision and criticized the court for acting like the legislature and for entering into a conceptual bog of trying to engage, to limit its decision to prospective only, to cut down the numbers of people who are being released by the effect of it, who would gain advantage of their new decisions. And as the good professor had predicted, the court did bog itself down. And following its lead of his criticism, your problem is with habeas. Habeas is a remedy, is not attended by res judicata. They can come back and come back. Your problem is with habeas. And the court took that signal, picked up by Justice Harlan and desist. And what they did then was undertake to reconsider the role of habeas, if you will. And they did that by first backing off the prospective retrospective, abandoning that, and then deciding Teague versus Lang, which didn't come out of the blue, as some people said. This was the ultimate suggestion of the good professor's article, which is a brilliant piece. And hence Teague v. Lang said, no, these prisoners do not get the advantage of these new decisions except the two exceptions of Teague v. Lang. And rather, it is a snapshot in time. They can only consider the law in place at the time. This serves interests of finality, et cetera, federalism, et cetera. Now, my point about these two dynamics is simply that for you to keep in mind that it is a fluid situation that we deal with habeas in particular. The habeas is a servant of other causes. Habeas is driven by capital punishment. There's little interest in habeas but for that. When I came on the court, my early years on the court, I realized that in fact, during the moratorium, the Congress proposed, and they had a bill before it, which would limit review in federal courts via habeas to whether there was a full and fair hearing below. End of story. It was uncontroversial. No one testified against it. It didn't pass only because it died for lack of interest. Then when we, of course, came back with the capital punishment, then came the large academic interest. There came the fight, and that is what drives the habeas enterprise itself. Habeas is all about capital punishment. The rest of it just follows along tail after dog. Those are two large observations that I wanted to make. One is my signal criticism is in the procedural side of the failure of judges to hear these cases. The others, of course, are the failure, unfortunately, of counsel. I conclude by saying that I come away with still a very positive view of this because on the counsel side in particular, such enterprises as today are quickly and have done a great deal to change that environment.
Thank you, Judge. And I think that perfectly frames, an area that we want to move into about the post-Warren Court era of habeas. But before we do that, I'd also like to ask the other panelists if they would like to address their first encounter with capital or appellate, or their introduction to capital or appellate post-conviction litigation. Judge Ellison.
I was appointed to the bench in 1999, and I spent my first 5.5 years in Laredo. I remember well my first capital punishment case. It came to me on habeas. It had been a sensational murder, a triple murder, a youth minister and 2 of his young charges. And despite what you've heard, Laredo itself is not a violent place. I don't speak to what's across the border, but the entire total of homicides in Laredo that year was 10, so This was 30% of the homicides in the city. It was committed with the use of an axe, and the details were, as you can imagine, horrific. The trial was pretty much a walkthrough, testimony from the serologist, studies of the blood found on the axe and on the accused. By the time it reached me, other facts had emerged. The serologist by then had been exposed as a total fraud. It led to the invalidation of his work in dozens of cases. He lost his license. He was a feature of a 60-minute special. But perhaps even more alarming, the axe, which was in the evidence room at the district attorney's office, had been used at Christmas time to trim the DA's tree. And this was a high-profile case, very important to the city of Laredo, implicating both murder and religion, and yet there was this kind of folly. I later read a quote from a surprising source, George Will, which captured my feelings about death penalty. He said, "For any conservative, death penalty has to be wrong, always and every time, because it places too much confidence in the ability of the government to get things right."
Thank you very much. John?
Thank you. I'm honored to be here. I'm by far the least distinguished member of this panel, in no small part because we mentioned earlier that for someone like Judge Higginbotham, his career has spanned sort of the post-Gregg era, his career as a judge. My life basically has spanned the post-Gregg era. I was born in 1974, and I too remember my first encounter with a capital case. It was before I went to law school. I graduated from college in 1997. I had a summer between college graduation and the commencement of law school, and I worked sort of as a runner slash paralegal assistant in a law firm during that summer. On day one, I'm actually sitting in the lobby waiting for the hiring person to come get me so I can fill out my tax forms, and a lawyer sees me and grabs me and takes me into his office and says, "I need your help. I need it now. I'm working on this pro bono death penalty case that is at the state habeas level, at the trial court level, involving a robbery murder in Hale County, Alabama, a rural county in Alabama." And I ended up spending a bunch of that summer not making much money for the firm, but getting great experience trying to work up the facts of this habeas petition for this gentleman who had been convicted of capital murder and sentenced to death. And the sort of the big issue that arose was a Batson issue. And I spent a lot of that summer in the era before cell phones, really, tracking down the original venire persons to determine, the African-American venire persons who had been struck, to determine whether the rationales given by the prosecutor had in fact been true, for the rationales for striking those venire persons. There have been some Supreme Court cases like this. There was some pretty egregious evidence that the prosecutor had been racially motivated. We had a strike sheet that somehow we'd gotten hold of that had the letter B by the black venire members, had the words "need reason to strike" by some of the venire members. And sure enough, when we were able to chase down some folks without the aid of cell phones in rural Hale County, Alabama, 2 venire members who had been struck on the basis that their family members had been in trouble with the law or had been convicted of murder or similar crimes, said, "No, that's not true. I don't have any family member who is in jail or who has been in trouble on that basis." And they actually came to testify at the hearing. So we had a hearing that was very much, I think, Judge Higginbotham's ideal at the hearing. It's very dramatic. The co-defendant came and pointed the finger at my client and said he was the one who did it, not me. We had the two venire members came and said, no, the prosecution grounds for striking were incorrect. So we had raised this fairly substantial Batson claim that was subject to some pretty serious procedural bars. So that was my first encounter with the capital system. Flash forward 15 years, when I take a position as the Solicitor General of Alabama. I show up, and within my first month on the job, my former client, Victor Stevens, has gotten a favorable ruling from a federal district court in Mobile, Alabama, granting him a new trial in his case on Batson grounds. And the office was trying to decide whether to take an appeal of that federal district court decision. And I had to rather sheepishly explain that I was conflicted out of the case because I had worked on it in 1997 as a 22-year-old. And I had to rather sheepishly admit that because the notion that I had worked on a capital case on behalf of the defendant did not sit well with some of the people in the Attorney General's office, interestingly enough. Well, no, I do find it sort of interesting. To end the story, the state ended up not taking an appeal of the decision and ended up doing what it often does in cases like that where federal habeas courts grant relief, new trials, and the like. They settled. No new trial, and the settlement generally is a life without parole commutation, reduction of the sentence. But that experience, my first experience with the capital system, which spanned basically 15 years, I think implicates a lot of interesting issues that are related to some of the dynamics we're looking at today. First of all, we had a case with serious Batson issues, which I, as Solicitor General of Alabama, unfortunately was encountering all the time. Batson issues that had basically arisen, in trials that had happened 25 years ago, but serious and troubling Batson issues nonetheless. You had a corporate law firm basically representing a capital petitioner. Interesting dynamic. We were fighting over an issue. Our best issue was really one that didn't relate to the innocence or guilt of our client and really didn't relate to the worthiness of our client's crime for the death penalty. It's an important issue. Batson is no doubt an important rule that strikes at a very important concept in our democracy. But the issue on which this guy eventually got relief and eventually got a reduction of his sentence didn't really relate to his guilt or innocence. The case also, my experience, illustrates what I think is perhaps the most important dynamic in capital litigation today, and that is the length of time it takes for cases to get into the system and the way that skews the results and also skews the deterrent effect of the penalty. And finally, as I mentioned earlier, my experience highlights the distrust you have between prosecutors and folks on the defense side in this case, a distrust that I think isn't very helpful to the system and something that we on the bar can and ought to work on getting rid of.
Thank you very much. Professor Owen?
Like John, I had my first brush with capital post-conviction litigation as a summer law student when, along with Raul Schoeneman, who's on the back row and is here at the UT Law Clinic, I spent a summer working for the ACLU Death Penalty Project in Atlanta under the tutelage of George Kendall, who many of you know and was here with us yesterday. The first case that we were assigned to work on involved a young man named Eddie Ross. Eddie had been 19 years old when he suffered a really serious psychotic break and, under the influence of his mental illness, raped and murdered an elderly white woman. Eddie was African American. This took place in a small town outside of Atlanta called, it was a small town then, now it's Decatur and it's nearly the size of Atlanta itself. Eddie had been represented at trial by an elderly and ineffective, and I mean that in a global sense, lawyer named James Venable. And Mr. Venable was noteworthy in Decatur because he would allow people to pay him along on the fees for his services. So Eddie's family actually hired James Venable to represent him because they could pay him $50 a month or $70 a month over time to defray the cost of his services. Well, the case went to trial, and the judge clearly was skeptical of whether Mr. Venable could do a decent job on the case, so he appointed a second chair lawyer who's a younger, more energetic, a little sharper attorney, and he quickly saw the case shaping up as one involving the possibility of an insanity defense. And when the case actually came to trial, he cross-examined all the state's witnesses with an eye toward trying to establish that Eddie had been mentally ill and actively psychotic at the time of the crime. So, for example, in interviewing or examining the police officers who had arrested Eddie shortly after the murder, he emphasized things like what was he saying, how was his eyes look, how was he behaving, was he acting rationally or irrationally, and so forth, and was building a pretty good lay case for getting an insanity instruction when the state rested its case. And during the break between that and the defense case, the young, energetic, smart lawyer went out to make some telephone calls. And the defense case was called, and James Venable put Eddie Ross on the stand to walk him through a completely preposterously implausible alibi about how he had been somewhere else at the time of the crime, and so forth and so on. And unsurprisingly, the jury then rejected the insanity defense and convicted Eddie and gave him a death sentence. And we were handling this case along with George in state post-conviction and went to look into James Venable's background. And what we discovered was, and it astonishes me that this was nowhere in anything we had seen or read until we went out to Decatur and started talking to people. And it turns out that James Venable had a long-standing and public association with the Ku Klux Klan. He owned a bunch of land out near Stone Mountain where the Klan liked to rally and liked to burn crosses and liked to wear their robes. And so he would routinely rent out his land for these Klan events. He was also a regular columnist for the Klan's Xeroxed, mimeographed newsletters that they would stick under people's windshield wipers in the grocery store parking lot or hand out at their events. And Venable had written column after column inveighing against young black men as a terrible danger, especially to elderly white women. And so we developed a lot of information about that, and armed with that, brought in an ineffective assistance of counsel claim, which ultimately was successful. The Georgia Supreme Court ordered a new trial, and their opinion says nothing about Venable's Klan connections, nothing about his personal racism, nothing about his making his land available for Klan events, nothing about his authorship of these screeds and the Klan's newsletter. It sticks strictly to the facts of the in-court ineffectiveness in calling the client to testify in a way that was inconsistent with the defense that had been developed earlier in the case. And so the lessons I learned from that were that much of the time the courts can be persuaded to do the right thing, but you have to give them the full picture, and that often the full picture may involve things that are so uncomfortable that nobody wants to actually talk about them. But that is, in fact, the real face of the death penalty in many of these cases. The second lesson I learned was a mistaken one, which is I thought, well, this post-conviction stuff is easy. We had this case, we worked on it for the summer, and we won. And so I unfortunately, the lesson I took from that was that I should march out from law school and start doing death penalty post-conviction work, which was not necessarily at least as easy as it looked at the time. But that was my introduction to this work.
Well, thank you very much. I want us to be mindful. We'll start talking about post-conviction work and appellate practice in a second. But I want us to be mindful because yesterday there were comments about the bad old days after Gregg and how trials were done back then and so forth. Rob just told us a very compelling story. And George Kendall mentioned yesterday doing this the terrible trials and then getting relief for people. And I think George is a supremely talented lawyer, and I'm sure George and Steve Bright, who's with us today, did get relief for a lot of people. But I want you to remember, as we're having these conversations about Teague and procedural default and all of the complex habeas doctrines, I want you to try to remember what the right to counsel, or think about what the right to counsel was like back then. In Texas, you didn't have a right, a death row prisoner did not have a right to counsel in state habeas until 1995. So for 20 years almost after Gregg, there was no right to counsel. In Alabama, I believe there's still no right to counsel if you're a death row inmate. So you do have, this is one of the reasons why you have NGOs and big law firms and so forth coming in to do this. So as we talk about this, be mindful of the fact, you know, who was dealing with all of this? How were death row prisoners dealing with that? So with those comments, we've touched on already in these opening remarks a lot of the themes I think I'd like to turn to now. As Judge Higginbotham mentioned, you know, that habeas, nobody was really interested in habeas until it became about the death penalty. And indeed, the reintroduction of the death penalty post-Gregg perfectly coincides with the Berger and Rehnquist courts' efforts to scale back habeas corpus. And there has been a huge battle, and a lot of this plays out in post-Gregg capital cases. You know, the court has said that, you know, in light of the profound societal costs that attend the exercise of habeas jurisdiction, we have found it necessary to impose significant limits on the discretion of federal courts to grant habeas relief. That's a quote from Calderon versus Thompson, quoting Smith versus Murray from 1986, both capital cases. The justifications for the court's scaling back of habeas are, you know, always comity, federalism, and finality. But other justices on the court, including Justices Blackmun and Marshall and Stevens and others, have criticized this scheme as a continuing crusade to erect petty procedural barriers in the path of any state prisoner seeking review of his federal constitutional claims, creating a Byzantine morass of arbitrary, unnecessary, and unjustifiable impediments to the vindication of federal rights. So I would like to start by asking our panelists to address how this Berger Rehnquist court's scheme of cutting back habeas has struck a balance, whether it's an appropriate balance, and how it has changed the nature of post-conviction practice in capital cases during the era. Anybody who would like to start? Bobby?
What's the question again?
So the question is, you know,
had such a great introduction,
yeah.
I lost the thread of the
so
question.
the thread of the question, I'm sorry about that. Let me rephrase the question. The question is, how has this creation of web of procedural defaults, Teague versus Lane was mentioned by Judge Higginbotham, procedural rulings, you know, Keeney versus Tamayo Reyes, all of these cases, how has this changed the nature of capital post-conviction work, and what has it done to the post-conviction work?
I'll take a quick shot at this and actually come at it from a direction not relating exclusively to the death penalty, which is that we should keep in mind that the federal habeas statutes are available. Judge Higginbotham made the point, I think, very well, that habeas to the public, habeas to the legal scholars, habeas to the courts becomes being about the death penalty, because that's the context in which the courts see the cases most often. It's where the stakes are the highest. It's where when there are counsel involved in the case, these kinds of procedural rules can become the substance of almost every appeal. But I think it's important to keep in mind that to the extent that the court has created an elaborate set of procedural requirements that are difficult even for trained, skilled lawyers to comply with, they are also making habeas essentially literally unavailable to the many pro se litigants who are in prison serving long prison terms, who may have equally compelling constitutional claims to bring of state misconduct, of racism in the prosecution, of ineffective assistance of trial counsel. But those prisoners are going to have to bring those claims to court themselves and navigate that very complicated and harrowing set of procedural barriers, often, always without the benefit of legal training, often without the benefit of any kind of formal schooling at all. And so I think that it's important to keep in mind that although we are understandably focused on the grave consequences of these rules for capital cases, that many of you I know are involved in the wider struggle for improving and reforming criminal justice in this country. And to the extent that the procedural barriers created in habeas, which are having this sort of restrictive effect on capital cases, I would just encourage us to never forget that they are equally daunting, if not more so, for the many hundreds of thousands of additional non-capital prisoners who might want to bring their claims to federal court for resolution.
Thank you. Anybody else?
Well, the problem with all our discussion is that it implicates much broader questions. The Supreme Court's role on habeas needs to start with the proposition that the Supreme Court in recent years has had very little idea what goes on in the trial court. Very little idea. When I look at the lack of diversity on this court, I'm reminded of the court that decided Brown versus Board of Education. At the time, there were 3 former senators. There were 2 former U.S. attorneys general, former solicitor general, former chief prosecutor at Nuremberg. The chief had been governor of one of our largest states. 4 of them had started their careers with active trial court practices. When you hear the Supreme Court talking about there was a fair trial, there was ample opportunity to ventilate the facts, I just wonder what image they have of the case. Have they factored in that death penalty cases are always highly emotive? Have they factored in the proposition that in Texas, where death penalties are promiscuously handed down, judges are elected? Does he understand exactly the dynamic for a judge in a high-profile murder case to come down on the side of leniency? Does he really understand that? I know most of the justices on the Supreme Court. I like them fine personally, but I mean, do we need 3 people from the same borough in New York? We do? Okay. Only one person from west of Mississippi who practiced spent any part of his career west of Mississippi. None who spent any part of his or her time south of the Mason-Dixon line. I mean, it's not that habeas needs to be cabined in death penalty cases. Habeas needs to be expanded in death penalty cases, because those are the cases where the hydraulic pressure to have emotion trump facts is the greatest. It's exactly the point at which political judges, politically selected judges, are under the most pressure. It's exactly the kind of situation that calls for the most searching post-trial inquiry. They got it exactly wrong. It shouldn't be limited.
I share many of those sentiments. It is sometimes, in fairness to the High Court, you know, when they get too deeply into the trial and the details of trials, they're not at their best. With all due respect to the justices and their brilliant law clerks, you don't get a lot of trial experience in the Harvard Law Review. One of my former clerks is on that faculty, and I spoke to him a few weeks ago, and I said, "Hey man," said, you got any brilliant kids around there who want a clerk?" And he said, "I'm knee-deep in judging and brilliant kids." He said, "Give me 3 or 4 days to find one that can tie his shoes." Well, courts don't do well, as neither do we, in dealing with matters of life, either it's on its front end, at its creation, or in its termination. Those imponderable questions are there, and they simply do not deal very well with them. One of the difficulties that I have with capital punishment and its administered is that it is different, and I see it as different in fundamental ways. Ideally, you would have a very separate path for capital punishment cases to proceed, and you would also have an innocence defense. That is, if you could demonstrate actual innocence, that everything else falls aside. The notion being that most of these procedural limits are in place for reasons that are extraneous and are frustrated, in fact, by the wrongful decision, of course, with regard to actual innocence. And it's actual innocence that in many ways is causing a lot of the support for reform of the processes that we're seeing. We are being confounded by the reality that our procedures that we're so comfortable with are inadequate too often in non-capital cases and convicting people that are proved to be actually innocent. There's nothing tells us that that hasn't really happened on death row. I haven't seen too many death cases in which there was a genuine issue with regard to, relatively speaking, of actual innocence, these legal innocence. Most of the cases I see are cases which the facts themselves are there and pretty well established. The real issues are over whether or not this particular punishment is appropriate. The other observation I have about that, with all the procedural protections that supposedly attend these processes, the court never, it seems to, for various reasons, never addressed that one of the other large forces in capital punishment, and that's race. I'm a product of rural Alabama. I think I understand, and I grew up in an environment in which everything, I did not go to school with an integrated school at all. I was briefly at the University of Texas, but I didn't see much other than a tennis court. But I think there were some minorities here. But that didn't happen. More than that, I look at Justice Marshall, who certainly did understand the dynamics of trial. And he certainly did understand the role of race. Any trial lawyer, and I was a trial lawyer before I was a trial judge, knows that this is a human condition, and it's a reality. The court dealt with it with regard to rape as an offense. They did it without talking about why. They look at the Balda study, which demonstrated the role of race. The reaction to that largely was that, first off, you had justices, none of whom had any real basic training in empirical work. Not only did they have a trial experience, like most lawyers, those justices, they went to law school because they were confounded by calculus. But those studies, there's a more fundamental reason why the court didn't go there, and I don't fault them for that. The implications of those studies were enormous for the whole justice system. So the court got there, but it did so by effectively just not talking about it. And you look at the amicus briefs that are filed in some of those cases, and the Legal Defense Fund and others, they made the case. And the fact of the matter is that the court didn't go there. Well, while one can understand that as a dynamic and understand how the court was functioning, the reality remains that it's still present, and it has to be guarded against carefully. That in turn means that the procedures and the processes have to be in place to ensure that. That means that you have to have extensive voir dire, which we normally get in capital cases, and you have to have lawyers who are skilled in conducting voir dire and who are skilled in eliciting the responses and really trying to get a jury that can be fair. I'd conclude my observation would say that, circle back to lawyers at the heart of this system. Counsel can do a great deal. The system has got a lot of problems in it, but one thing that it cannot tolerate is weak counsel. It's more than that. A trial functions just like the old milk stool on the milk farm I grew up in. 3 legs. If any one's shorter than the other, it wobbles. You got to have a strong judge, you got to have a strong prosecutor, and you got to have a strong defense counsel. And when you get those 3, you have a very good chance of proceeding to a just cause. The difficulty we have is that the weak leg is likely to be, in capital punishment, it's likely to be the defense counsel. You think about it for a moment, you see what? In fairness to their state trial judges, think about how they're staffed. I tried major civil cases in the state court of Texas to a judge. Because I was forced to, I've never tried anything to a judge I could try to a jury. And then after 2 and 3 weeks of very complicated testimony, very complicated transactions involving commodities, securities, and things of that nature, antitrust, what do you name it, the judge would call and say, well, Patrick, said to you, I found for you. Bring me the findings of fact and conclusions of law. 2 weeks, I would write up findings of fact and conclusions of law, take them down, the judge signs them. Now, if you can't write findings of fact and conclusions of law that will withstand appeal, you ought to get out of the business. That's the civil side of the docket. And there's exceptions to that, of course, and it's not that the judges didn't want to do that. They had no secretary when I was trying these cases. They had somebody in the clerk's office that filed papers. They had no law clerks, and they were on the bench most of the day. When were they going to have the time to read the briefs and to actually engage? And most of the time, they ruled from the bench and did a pretty good job, seat of the pants, and complicated matters. But you have some really institutional deficiencies. The judges are elected. They're understaffed. Now, what does the trial judge do when he's got a motion filed before him to grant a hearing that might cause a stay of an execution of a case he's tried, and the morning papers has got the headlines of it, horrific murder, scheduled for execution? The judge is conscientious. He wants to do the right thing. But the pressures are to let someone else deal with it. In other words, I can't really solve this problem because whatever I do is going to be looked over anyway. And so I'm just going to kick it on down the road. So it's very, very difficult in that kind of environment to make the system work as best it could. But the keystone, the key thing in this is defense counsel.
The only thing I'd add is the relative new kid on the block with respect to the innovations by the Berger, Rehnquist, and I would add O'Connor courts, is that in addition to the Teague versus Lane non-retroactivity rule, the other major innovation I would say adopted in particular by Justice O'Connor, whom we tend to forget, was pretty far right on habeas issues, such that the current court I think is far left of the Rehnquist court because Justice O'Connor is no longer present. A case like Coleman versus Thompson, I think, would never have been decided by the Roberts court. And if you read back on it today, I mean, she drew some very, very hard and tough lines there. But as a result of those tough lines, the name of the game, for lack of a better term, among state prosecutors, as far as I could tell, state appellate prosecutors, was to look for the procedural default. And if you can win your case based on a state law procedural default, do so, because that gets rid of the case relatively quickly and gets rid of the case often without a hearing. And that would turn out to be a very powerful weapon for prosecutors. I'm not sure that the O'Connor approach to procedural default was wrong at all. But I did have concerns during my time as a state appellate prosecutor that maybe it led the state to fail to play the long game. And what I mean by that is that state prosecutors became so accustomed to relying on procedural defaults, which by their very nature come off as harsh and unfair, that the defense counsel, people representing capital petitioners and other petitioners, looked like they had sort of the better hand in terms of justice. They could argue that their client was actually innocent. They could argue that their client had never had a hearing. They could argue that their client's constitutional rights had been violated. So at the end of the day, I wonder whether, as a result of these fairly bright line rules and pretty hard rules that Justice O'Connor and Chief Justice Rehnquist laid out in their jurisprudence, the state ended up in a position that eventually has become a little less tenable with a different court, and a court that may be even more different depending on what happens with the vacancy created by Justice Scalia's passing.
I will say I think Justice O'Connor's approach to procedural default was wrong. I understand we would be coming at that from slightly different perspectives, but I just want to make sure we keep in mind that a regime of procedural default, a regime in which federal courts decline to entertain substantive federal constitutional claims. For example, my confession was beaten out of me, or my lawyer slept during my trial. The federal court declines to hear that claim because the defendant at some point during the state proceedings failed to follow a procedural rule about how that claim should be presented. He filed it on the wrong day, he filed it in the wrong court, he filed it a day late, he filed it without attaching affidavits, he didn't cite the right court cases. In other words, it is a refusal to look at substance on the basis of procedure. You can defend that regime only if you are guaranteeing meaningfully effective counsel to defendants in the state proceedings. Once you have good lawyering at the state part of the process, it is at least defensible to say that we will then thereafter not entertain claims which lawyers, good lawyers, effective lawyers, should have presented effectively and failed to do so. The problem that I always saw in the procedural default regime of the Rehnquist, and I think it is accurate in some ways to call it the O'Connor court, since she was in many ways the driving force behind the court's habeas decisions, certainly in Keeney versus Tamayo-Reyes and Coleman versus Thompson and other key decisions. But the problem with that regime was that it treated defendants as though they had had effective representation in the state proceedings, effectively punished them for not perfecting their claims in certain ways, when in fact that was a fiction. Many of those defendants had never had effective representation in the state proceedings, and the consequence of that was neither the state courts nor the federal courts were ever examining the substance of the constitutional violations. So if you're going to give people good lawyers in state court, then it's fair or reasonable at least to enforce strictly the procedural bars in federal court. But if you're not going to give people decent lawyers in state court, then it's really mousetrapping them to turn around and say, and we also won't hear your claims in federal court because, aha, you filed on the wrong day in state court.
I think that another point to be made about this, and this goes to one of the driving interests of these decisions is comity, is you can give people good lawyers in state court, but you also have to give them access to good courts. Are there any Texas state judges in the room? Okay, good. We're going to talk about them now. Judge Higginbotham mentioned the trials in which the prosecution, or the prosecution, but the prevailing party is asked to draft the proposed findings of fact. I think that for anybody, my post-conviction career has been limited to Texas, and what we often see here is a regime in which the findings of fact and conclusions of law, to which all of this deference comes due once they get to federal court, are often drafted wholly by the prosecution, in my opinion, sometimes without any sort of basis in the record. And it raises the question: is this comity interest really due? Are the states a co-equal player in the habeas corpus system when I think what happens in some of the state courts, and I'm not going to say all of the state courts, but in the ones in which I practice, often is very different from the sort of habeas corpus litigation that we have in federal court. And yet, not only do we have the fiction perhaps that people are getting counsel or good counsel, but there's also, I think, a real problem with giving this sort of respect to the state courts if they're not giving the process. If it's a paper hearing, which is oxymoron, I think. It may be that civility and so forth may prevent folks from commenting on this, but I am curious about the perceptions of what happens in state court habeas litigation, because that is supposed to be in the habeas system where the action is. Okay, go ahead.
Well, I think that Judge Higginbotham correctly observed that state judges, many of them, do not have the same resources as their federal counterparts. And for that reason, they may fall more readily into the habit of asking the prevailing party to draft the findings and conclusions, which then become the basis for subsequent review in the case. And so, I'm not prepared to fault the judges. I will fault a system that does not equip them with the resources to treat the cases seriously and provide the kind of searching review that at this point we are still generally only getting in federal court, largely because not just of the quality of the judiciary, but the quality of the resources they can bring to bear. They have the assistance of well-trained, talented young law clerks. They have the opportunity to, if the law otherwise permits it, to hear evidence, to allow us to conduct discovery, to give us resources for experts, other kinds of things that can improve the quality of the fact-finding and really make the proceeding much more robust. I think that in state court it would be better if there were more process there. And again, I think that calls on the state, meaning the state of Texas, to fund the judiciary to the extent necessary to make those proceedings meaningful. As it is now, both Judge Higginbotham and Jim Marcus have both said, in state habeas, what happens is the defendant files his application, which sets out the errors he believes happened at his trial. Often he supports that with suggestions of evidence, as it were, affidavits, documents, other kinds of things, saying, in effect, if I got a hearing, I could prove this. And here is the proffer of those facts. And then the court asks the parties to submit proposed findings and then signs often one set of them. Texas Defender Service did a report in the mid-90s that showed that in over 80% of Texas post-conviction cases in the period studied, the trial judges adopted the state's proposed findings without changing a single thing. And these are over 90%. Okay, I had the numbers low, but it's a very troublingly high percentage of cases in which the judge treated the case as though it were completely one-sided and adopted one side's argument about these are the historical facts. This is what the lawyers did and didn't do. This is what the police did and didn't do, all without the benefit, as Judge Higginbotham said in his opening remarks, of a hearing where people have to testify in front of a judge, where they have to be subject to cross-examination, where they can be confronted with other evidence. And we shouldn't be surprised that a proceeding which is so fundamentally one-sided and deficient produces unfair and inaccurate outcomes, because the very engine that our legal system has developed over hundreds of years to reliably resolve disputes of fact is not being employed in these cases. And that is the reason that there is so much, I think, problem with the state court. I'm not blaming the judges again. I think there needs to be more of a more robust or full proceeding for fact development.
Judge Higginbotham.
Just a quick comment. One of the things that looms large in the state processes, of course, is the cost of litigation. A prosecutor outside of Texas, outside of Dallas, Harris County, or Bexar County, where 68% of the population of the state reside, is faced with a terrible crime in his community. There's a lot of pressure for him to seek the death penalty. But one of the things that he has to put into his calculus is the cost of this. The cost of the county is going to be large. Then you get a counsel that when they go through the process, it seems like it never ends, because then you come back eventually 8 years later, and the person is now entitled to a Ford hearing to determine competence to be executed. So you're back before the trial judge, and you ask, Judge, would you appoint counsel and give us some money to do this? And I've read these transcripts, and the trial judge said, well, you have a lawyer. And he said, yes, Judge, but we need appointment, meaning they need compensation, the money it takes to do this, et cetera, et cetera. What's going on is that it is basically who pays for this. If I sign this, we're talking about a $200,000 tab, or realistically, that's going to be dropped on the county. In this rural county, this kind of $100,000, $200,000 bill unscheduled is a problem. It's a problem from local politically, and it's really a problem. The cost of this whole enterprise is a large elephant in the room. And others have said that if capital punishment is ultimately ended, it will end because the people who are enthusiastic about it are really willing to pay the bill.
Judge Johnson, did you want to?
Just one, I don't know, not a note of dissent, but a note of amplification. I do think we have a lot of superb state court judges in Texas. I see some of the superb habeas counsel we have in Texas here with us today. I don't want to let pass the notion that all defendants are getting substandard representation. Some of them are getting really excellent representation from really selfless people. I grew up in the South during the integration crisis. I think it's just a sad fact that irrespective of the qualitative range of elected judges, integration would occur because of unelected federal judges. I don't think that's a bold statement. I think that's how it happened. If we're going to see progress on, and we all know how abortion happened, the legalization of abortion happened, there are real limits on what a state court can do when an election is looming. I mean, Judge Justice's name's already been invoked this morning. I love the man. I was the chief eulogist at his funeral. If he had been issuing those decisions in Tyler, Texas, as a state court judge, his tenure would have been exceedingly brief. I mean, 1/6 of the population of Tyler called for his impeachment in a petition. He could do what he did because he didn't have to face the electorate. Now that in itself raises a whole lot of questions. Do we want to have that much power in the hands of those who are entirely unbridled by the citizenship, by the citizenry? But it's asking an awful lot of a state court judge to do anything on behalf of some of these accused criminals in capital cases, because the upside of doing that is non-existent. And the downside is you provide your opponent at the next election with a very winnable campaign theme.
I echo that. I want to share one observation about Judge Justice, since he is one of his name appears in some of the papers here. Wayne was a friend, and I told him, not too long before he died, that I had run in and down on the streets of Dallas. A friend of mine came up to me, and who had been a Republican activist, and said, "Say, Pat," he said, "I saw in the paper where Wayne Justice has joined whatever the whole county operation down some decree had entered, he said about it." And I said, "Yeah." And he said, he looked at me and he said, "I thought that son of a bitch was dead." I said, "No, I don't think so." So I saw Wayne a week or two later, and I told him that story, and he loved it. So there's no question but that. I think that Judge Ellison makes the point very well, that the pressures that are there. We would like to say that someone would be noble and rise to the occasion, but then he will not be long a judge. Down in Alabama, I saw that they were just now decided to celebrate the trial judge in the Scottsboro cases, and then erect a statue to the judge in those cases who had ruled against the local community, but he was no longer a judge. In practice law, continued to practice all those years, and the state has gone back to recognize the courage of that trial judge in those cases themselves. We can't expect and demand that on a daily basis, routine daily basis of our state court judges. So when we talk about reform or changes that will help the system, there's some things that we have to accept as given. Texas has chosen to have an elected judiciary, and they've elected to put them on a partisan ballot. The latter move, I think, may be the more damaging factor. But then that's a reality that we work with. Now, given that reality, which we're not going to change, what do you do? And that goes to the question of, given that reality, is there some way that you can escape the biting of AEDPA, that the federal court's limitations in place, that is, the limitations upon this review of state court system. I don't have an answer to that.
Well, I'm more of a believer in state court judges than I think some of my fellow panelists, in part because I suffered plenty of losses at the hands of state court judges when I was an appellate prosecutor. But you know, I hear what they're saying on those fronts, and part of me again wonders whether, especially in light of Martinez versus Ryan, the recently decided Supreme Court case that I think took a bunch of the teeth out of Coleman versus Thompson, I wonder whether the states are really thinking through the right approach to these issues now. The sort of premise of the O'Connor habeas jurisprudence and the premise certainly of AEDPA is that the state courts need to be the driving forces behind the litigation of post-conviction cases. If you're a state and if you're a legislator who doesn't want to spend money, your state's money, you don't want to raise taxes for this sort of thing, why even engage in it? Why not just say, you know what, the federal courts are going to be reviewing our courts anyway. It's going to cost us money to litigate these things, and most importantly, adding that layer of state habeas review is going to inject another decade or so into the process, a decade that is extremely problematic from the perspective of those who want there to be capital punishment and want it to have a deterrent effect. So, you know, my modest proposal might be, if you're a pro-federalism person, as I am, if you're a pro-states person, if you're a pro-prosecution person, maybe the right approach to this sort of thing is to say, as states, we should just get our hands out of this whole habeas business and let the unelected federal judges do the work for us on the federal dime rather than the state dime.
And I think, you know, we're running almost out of time, but I do want to turn to, we haven't even really talked much about the Anti-Terrorism and Effective Death Penalty Act, AEDPA. You know, in talking about the pressures on state court judges, funding in state court, other issues that make it difficult for state courts to neutrally adjudicate federal constitutional rights, what we've done with AEDPA is not sort of given more sort of leniency or forbearance to the state courts, but we've done just the opposite, right? Now AEDPA has given more deference, greater deference to the state court decisions, and to the point where federal courts now are not asked to look at a trial and decide whether there was a constitutional violation, but instead to look at the state court decision about that issue, regardless of how it was arrived at, and decide, is that so wrong as to be unreasonable? So it seems like we have now moved even one step further away. And I was wondering, particularly from the perspective of the federal judiciary, you know, how, you know, what it feels like to be adjudicating habeas in the post-AEDPA era.
What's been bad has been made worse. Is there anything more to say?
One of the things that's on the horizon potentially is the other, in addition to the 2254D issues, is this opt-in fast track. I mean, somebody made a comment earlier about how we should have a separate track for capital cases. We've created that, and no state...
Too big a price tag. How do you opt in without undertaking to create the system that costs that money? I think the general over here is as right as he can be about the cost. That's a large, difficult problem in the whole system. Death penalty is different, and it doesn't do well and running on the same track with a whole host of others. Ideally, they would be separated, and then you could isolate cost perhaps and be more focused in it, and then you could force the decisions upon government as to what they want. If you want to exercise your rights, you have to pay for it, but it gets lost in the total blend of prisoners, et cetera, et cetera.
What troubles me most about the special legislation on death penalty is it's so asymmetrical. If we are going to say death is different, and therefore we need this special statute to confront it, why can't we also say death is different, and this is the one area where we're going to look at race? I mean, the argument, I think, that's kept race out of the mix in the Supreme Court has been, if we worry about racial disparity in the death penalty, won't we have to worry about racial disparity in traffic stops? But if we're going to say that death really is different, it shouldn't be different just for lowering the standard of review on habeas. It ought to be we take account of the cosmic questions too. It is different. Let's talk about the influence of race on death-eligible defendants.
I think the jurisprudence of the Supreme Court demonstrates that death is different.
Not on that issue.
I mean, in a concept, and that's what I'm, in other words, if you think about it for a moment, the entire construct of that we're working with now, it comes at the hands of a court. ADPA comes in and controls it, but the Supreme Court has to, first off, shut it down, then they brought it back, then they created a unitary system. They ended the unitary system. They created a bifurcated system. Then they created these various guided discretion processes, et cetera, et cetera. We can talk about the difficulties along the way of administering those things, but my only point is that this is very much a construct of an appellate court, the Supreme Court of the United States. As you say, it's responding to the cases that are out there. It's what it has done is to take a period when the death penalty was gone and then construct this whole system. Because all of these is by judicial decision for the most part. Virtually all of it. I don't see the Congress taking a really heavy hand in this beyond AEDB, which is significant. But that's it's not whether death ought to be treated as different. It is being treated as different, but that's the rest of it. It's been forced. Other cases have to follow along with it because death is the driver.
One thing I saw all too vividly when I was State Solicitor General, perhaps your own state legislatures are more functional than mine, but we had grave difficulty getting anything through the legislature, even simple fixes that shouldn't have been controversial or really should have been pro-prosecution. You know, after I lost Miller versus Alabama, we needed to fix to our capital murder statute to give courts an option to sentence juveniles convicted of capital murder to something besides life without parole. We could not get that passed, and it wasn't because we had a bunch of opposition on the left or even opposition on the right. We just couldn't get it done because the legislature was too focused on other things. So the idea of getting a legislature to opt in under the provisions of AEDPA strikes me as fanciful, at least at this point in Alabama, and I imagine in many other legislatures across the country.
Well, Texas, I think 2 states have pre-applied, and Texas is one of them. The other is Arizona. So we'll see whether Texas makes it in. Texas has made a lot of progress actually in the area of state capital post-conviction representation. Were you about to say something? Oh. I wanted, before we open it up for questions, one thing that occurred to me yesterday as we were sitting here talking, and is that in the immediate era post-Gregg, there were several Supreme Court decisions that had the effect of looking at the post-conviction statute or various area of capital punishment jurisprudence and deciding cases that wiped out numerous death sentences in one fell swoop, sort of big systemic decisions. And as time went by, fewer and fewer systemic challenges were getting sustained. And part of, one reason for that might be is that the court had settled in on its jurisprudence and it had decided that everything was working well. But another reason could be, and I had the great privilege of accompanying Rob and Jordan when they were arguing the Penry-related cases, one of the things that the Supreme Court always asks in those arguments is how many people will be affected by this, and so which seems to me an entirely irrelevant question on whether or not our statute was functioning in a constitutional manner. So I think that is some consciousness of the political ramifications of the decisions. But this year we've just had in Hurst versus Florida a sweeping condemnation of the Florida statute, which I think also calls into question Alabama statute and I believe Delaware statute, 40 years after Profit. And I was wondering, besides it being obviously quite a significant development for folks in those states, if this is any sort of a signal about the Supreme Court's perhaps willingness to re-enter the fray of looking at the constitutional regulation of the death penalty in a more significant way.
Well, one experience we have with the frustration of the court with the Congress is you recall that Chief Justice Rehnquist appointed Justice Powell to head the Powell Commission when Justice Powell stepped down from the court. And he had very distinguished people working with him to develop proposals, et cetera, to deal with, among other things, with successive writs, which needed some kind of regulation, I suppose. And then he appeared and testified before the Senate Judiciary Committee. At the request of the chief, I accompanied there, and we had this hearing before the Senate Judiciary Committee. And of course, with Justice Powell there, all the lights were on and so forth, and they were all good. Justice Powell was so gracious and so forth. And then he said, well, I've learned from my colleagues here and let them answer the questions. And at which point, the senators, all of the senators but two left, when the lights went off, they were polite with regard to the suggestions, but then quite plainly, they were not going to do anything. And then, not surprisingly, within the next two terms of court, the essential terms of the proposal of the Powell Commission with regard to successive writs became the law of the land. So the Supreme Court there was asking for legislative assistance, recognizing the limitations of its own role. And so I don't think we can fault the court in its struggles with the Eighth Amendment and the evolving standards, et cetera, to have constructed this. My point is rather that it is a construct, and that it is an incremental adjustments have gone along the ways that some of these things just haven't worked, or they've worked in perverse ways. And I think the question of the court about who this will affect is the angst of the court as to what the consequences and implications of their decisions are. Part of it is a lack of maybe a trial experience. We could joke a little bit about that. But we have on the court and across the board enormously talented people who are committed in their hearts and minds to creating the fair system proper. I think that they have different views about how to get there, but that is an institution. So the question, what institution would you rather have do it? You're going to look to the Congress, you're going to look to the state legislature. So it has been a judicial construct. So I come away, though, despite the difficulties and the warts along the way, and trying to be a judge in the system, a lawyer in the system, I look at where we are now, and I look back to where we were. And I can only say that we're moving very much in the right direction. And I would end this morning on a very positive note that as I look at the people here, the bright young talents that have devoted so much of their lives and careers to this, we were left with, I think, ought to be pleased with actually the bar in general and the lawyers that are doing it. But it is the lawyers who have to shoulder this burden. No one else is going to shoulder it for you. And it is the lawyers that have taken it up. Now, we'll disagree about some of the ways along the way, but everybody, I think, is pushing to the same end. But I would finally conclude that not only do the courts not do well with regard to the beginning and the end of life, they don't do well with cognitive function either. Trying to probe judicially the qualities of a mind that are sufficient to be aware of whether they can be executed is a challenge to highly trained psychiatrists. And it also, that whole enterprise sort of defies in some ways the reality of how little we know about the human mind. Nonetheless, those particular challenges have to be met by the court. And so their ineptness and crudity, as it sometimes seems to be, is built into the process. We have the system that's got a lot of problems, but it remains the very best legal system in the world and the fairest on balance in the world. It also remains the fact that we're the only free nation that still maintains this penalty. So there we are.
Thank you. I would like to, unless somebody else has further comment, I would like to open it up for questions from the audience. We have about 5 minutes, and we have the lovely and talented Lachlan Rosen is now going to assist people with a microphone.
While Furman was not, of course, a habeas case, the moratorium strategy behind it depended enormously on Fay v. Noya and the habeas jurisprudence of the time. At that time, at the very most, 5% of all federal habeas petitions, including non-capital cases, resulted in the grant of the writ. With respect to state habeas or post-conviction at the time, the only reason we used it was, of course, because of the exhaustion doctrine and to postpone, for time reasons, to postpone the date of a potential execution. Most of the state habeas petitions I filed were denied by postcards. I have the very vague impression that as bad as state habeas or post-conviction may be today, it's better than that. But I wonder if the panel has any statistics about the percentage of state post-conviction petitions that are granted. My suspicion is it's very, very small.
Nancy King at Vanderbilt published a piece a couple of years ago assessing about 10 years worth of habeas success rates, not just in terms of ultimate grants of relief to the conviction or sentence, but also intermediate forms of relief like getting an evidentiary hearing or getting a certificate of appealability to allow an appeal. And I'm going to embarrass myself and say I don't remember the numbers, but they were very low. And I think they were at least, they were no better than the your sort of spitball 5% rate that maybe you were seeing in the 60s. 5% was the highest. Yeah, it's lower. It's certainly lower than that. Now, I don't know if Jordan or Carol, anyone else has actual numbers on that, but it's low.
The comments about the state judges, there's an important case, I think, that's pending in the U.S. Supreme Court now, Williams versus Pennsylvania, which Jenny Sloan organized an amicus brief for some of us former appellate judges. And it was the district attorney of Philadelphia made the decision to seek the death penalty against Williams, and then he ran for the Supreme Court Chief Justiceship on a platform of being in favor of the death penalty. And when the case was reversed on post-conviction in the trial court, it went to the Pennsylvania Supreme Court, and he did not recuse, and they reversed the case. So I think that's an important case because the elected judiciary is a problem, and the Supreme Court made it worse in the Minnesota GOP versus White case, where they said that you had a right to free speech and make, in effect, campaign promises. We tried to ameliorate that because in Missouri, even though we have the sainted plan, about 110 counties elect judges on partisan tickets. And we said, if you're going to make a promise, then you better not sit. That's in effect what our rule says. So the problem of recusal is a real problem, and I wonder if anybody is seriously thinking about that in terms of the state judiciaries.
I don't see a lot of growth in affecting recusals. I really don't. One recent campaign for the chief judgeship of the Texas Court of Criminal Appeals, her entire campaign theme was, "I am pro-prosecution." I tried to imagine whether anybody could win on a platform of "I'm pro-defendant."
How about fair and reasonable?
Lockton, we have time for one more question. Lisa is in the back there.
Fair and reasonable is awfully soft in Texas.
There's a lot of questions I'd love to get you to answer, but the one that's on my mind is, in the post-life without parole environment now, we've had a decade where every state has had that statute on the books as an alternative. We've obviously seen this huge drop in death sentences, but at least according to statistics that are available from various sources, you do have some counties, we had a speaker yesterday talk about Harris County in particular, and there are others, where in fact, every death sentence in the last decade has gone to a person of color, either an African American or a Hispanic. At what point does the disproportionality of race issue become something that the federal judiciary has to address? Because certainly it's not true that 100% of the people who commit capital murder are black or Hispanic.
I'm all for the courts looking at race in capital punishment and every other cell and membrane of the criminal process. Your question raised another point in my mind. I think the fact that people ask, what is the death penalty that significant given so few executions? I think we have not ever looked at the externalities of the death penalty. I think the fact that we have a death penalty makes life without parole seem much more reasonable. It makes the entire federal sentencing guidelines seem more reasonable, though looked at a priori, the sentences are very high. And I just wonder, I mean, we're in the realm of hypothesis now, but I just wonder what other externalities there are about the death penalty, the fact that the state executes people. Are we for that reason, more able to tolerate police violence against unarmed citizens? Are we for that reason more willing to condone drone strikes? Are we for that reason more tolerant of unjust wars in foreign lands? I don't know, but the fact that our state embraces the task of killing people, I think it just goes way beyond the death penalty.
Well, I think we're out of time. I want to thank our very distinguished panel for being with us this morning. Thank you very much for coming.
Thank you.
Very nice to meet you. Good to hear from you.